Good morning all. We are here for the case management conference in the matter of CFI 067-2018 before Judicial Officer Maha AlMehairi. The claimant is represented by Clyde & Kerr. Lead counsel is Nicholas Procanza. The defendant is represented by LPA Law Firm. Lead counsel is Nigel Partridge.
Good morning. I'm here on behalf of the claimant just to discuss the case management order. Can I just check that you have received all the documents filed with the court?
Yes.
There is one preliminary issue which I want to draw to your attention, and that's the question of applicable law applicable to this dispute. We have had correspondence over the last few days, and we can consider that this issue can be dealt with by consent, and that the applicable law that will determine this dispute will be non-DIFC law, UAE law as applicable outside the DIFC. So that is one issue that we dealt with by consent. How would it help us to go through the case management order item by item? And
other than that, all the issues are, as I can see from the order, it's agreed.
Almost entirely. There's a couple of small issues which we need to discuss.
We can go through the order together.
Yes.
Yeah.
But the issues in the case have been agreed. I think that's what you were referring to.
Yeah.
Yeah, there's an agreed
with
list of issues.
List of issues, yes, absolutely. Yes, that is it. That is great.
So other than that, which version is agreed? The defendant's version or?
In terms of the case management order, and they're not agreed yet. They are mostly agreed. There are a few issues that we need to discuss with you today. If it's probably easiest if we go to tab 2 of the case management bundle, where we have the markup for ours, the original claimant's the original version, and it was marked up by counsel for the defendant. You'll see the first issue is alternative dispute resolution, which is not agreed by our clients. We do not consider that a period of any period is required. There has been correspondence between the parties, both in the immediate recent past, but also right at the outset of this dispute regarding settling this dispute out of court. It has not been successful. We see this as a delaying tactic by counsel for the defendant, and we don't think that it's appropriate. If the defendants wish to make an offer to our clients, we will readily hear it, but we don't believe that a stay is necessary or that a mediation is appropriate in the circumstance.
Thank you. On the question of the alternative dispute resolution, the claimants in the information sheet said that they remain open to the possibility, I think there's a word missing, possibility of alternative dispute resolution. We are of the view that this is a case which is particularly susceptible to resolution outside court through alternative dispute resolution. It's been going on for some time. The parties know the issues very well. It comes down to what can be a fair and amicable settlement between them. We have corresponded with claimants' counsel to have the reply back that they would consider any offer, their clients would consider any offer which we might make, but that shouldn't impact, if I'm not misquoting you, shouldn't impact the court timetable. Our view on that is that we are encouraging our client to consider seriously an offer and to make one. We would like, however, it to be done in the context of a more formal mediation, not necessarily the initial offer being made. We can perhaps persuade our client that to show good faith an initial offer should be made. However, in order for that offer to be dealt with effectively, we consider that ultimately a fallback position for discussion between the parties should be mediation. And that's why we built in to the court timetable what we consider to be a reasonable period of time for that exercise to be carried out effectively, rather than just contenting ourselves with a back and forth on a without prejudice basis with the claimant. We would like that exercise to be built into a proper mediation procedure, where ultimately a mediator would interpose him or herself between the parties in order to find common ground. I think my learned friend referred to past discussions, and I think probably what was missing in those past discussions is a mediator, someone who knows the media sector well, who can sit the parties down, say, let's be reasonable, and find a solution to this, rather than the parties just sending back and forth proposals. So that's why we feel that we could usefully build into the court timetable a reasonable period for mediation to take place. Our suggestion is that that should be a deadline would be 5th March, which I think gives a reasonable period, keeps the parties minds concentrated on process, finding a mediator, getting the agreement signed up, and the mediation to take place. The mediation itself would probably only take a day, if not just a bit more, but the process just needs a bit of time to be put in place. This should not be considered as a delaying tactic. I think that is an unfair statement on behalf of the claimant. Should be considered as a genuine attempt, having exhausted in this, to a certain extent, the preliminary procedures to find a solution, rather than going ahead with a full-blown trial in this court, which of course will happen if there's no resolution under the mediation process. We think it's a fair and reasonable proposal that a reasonable period should be dedicated to this procedure.
And are you in the process? Have you tried mediation or mediation discussion between the parties before?
So far, there has just been from us to the Claimants Council a request that we settle this by ADR, Alternative Dispute Resolution. And the reply back was that they were open to any proposal that our clients may make, but the court timetable, this court's timetable, should not be disrupted or delayed to the extent.
Could I just clarify? Actually, it wasn't we were open to a proposal. We were open to an offer of settlement. If they had an offer to put on the table, our clients would consider it. And I'd also like to correct that. Yes, there has been this recent correspondence. There have been a number of meetings between our client's chief executive and the Council for Defendants chief executive as well. Many times they had attended conference calls, they attended meetings in person right at the outset in 2016 a number of times. There was no resolution, the parties didn't even come close at that stage. Our client strongly objects to a mediation. I don't think that this is anything more than a time-wasting exercise. At every opportunity, the defendant has tried to derail these proceedings with its jurisdiction challenges, of which you'll be aware in the parallel proceedings, and so we strongly object. I think that if the court does wish to grant a short period for the parties to engage in alternative dispute resolution, that may be acceptable, but nothing more than a week or two. I don't see that it's necessary for us to stay these proceedings for months while we engage in mediation, which our client strongly believes will not succeed.
The court is open for a 2-week period for mediation. The dates will be shifted from that. So we're looking at tab 2, and we can work from that version.
This is the case management order as amended by the defendant.
Yes.
Is that correct?
Yes.
So 2-week period for ADR falls on which day?
But may I suggest that we take the date that the claimant offered, which I think was 8th February, and add 2 weeks onto that, 22nd February?
Okay.
Yep.
Yeah, we can agree to
Yeah.
22nd February, okay. And then, of course, tab to the next, the preliminary issue is struck out. That's been with my defendant.
Yeah.
So,
Yes.
and if I can just say that the rest of our comments are really a knock-on effect on the timetable triggered by the first amendments. So probably we're just talking about plus 2 weeks.
Plus 2 weeks.
To the rest of the.
Okay. Other than that, are there other issues to discuss?
There is a small point, which is that the agreed list of issues, the witness statements and the expert reports must be annotated with references to the relevant list of issues.
Yes.
As the court will note, there are very few lists in the list of issues. We're now have only two issues, I think it is now. It's unnecessary, I think, for us to annotate each and every paragraph of the witness statements and skeletons with respect to the list of issues.
I think there's a practice direction that deals with
Yes, you're correct. It appears in the standard form issued by the court, but in practice, the court regularly doesn't apply this, so I don't think it's necessary.
I think they do apply.
Okay.
Yeah. So this should be applied.
Okay.
Is there anything else?
Should we talk about witnesses and experts? We've indicated in our case information sheet that we will have 3 witnesses, and all of those individuals are available for cross-examination. The defendant's counsel has indicated that there will be 4 witnesses, but only 2 will be available for cross-examination. The claimant will require all witnesses that the defendant wishes to put forward as witnesses to be cross-examined in trial.
So in total 6?
Yes. Sorry, no, 4 from their side, 3 from our side, so 7 in total.
7. And you want to cross-examine?
All of them, yeah.
That's fine.
Yeah?
The number of experts as well. Claimant wishes to call a quantum expert. We believe the defendant also wishes to call a quantum expert. The defendant has also indicated that he wishes to call a media market expert. We do not believe that a media market expert is appropriate or necessary in this case. That one expert from each side. If there are media-related issues, they can be dealt with by evidence of fact, witnesses of fact. So I don't believe that a media market expert is necessary. Fundamentally, this is a straightforward debt claim, and issues of the media market, whatever that may be at the applicable time, are not really relevant.
Yes, I don't think we'll be calling a media expert in addition to a quantum expert, but I think we'll merge the two capacities and have the quantum expert familiar with the sector.
Yeah, we're happy with that then.
Yeah. No issues there.
Yeah. The defendants indicated it may wish to amend its defence. Our claimant remains is open to that, but insists that the procedure as set out in the RDC, Part 18, is followed. That this will not be, we will endeavour to agree these by consent, but if the court's involvement is required, then so be it.
According to the RDC. Yeah?
Okay. No further issues then. Thank you.
Okay, then please send us a draft of the CMC so we can issue the order. Yes? Thank you both of you for your time.
Thank you.
All right.